or maybe where you are, it is actually good afternoon or good evening. I just want to set something right here on my computer, and then there we go. Right, let me say that again. Good morning, good afternoon, good evening. I'm Professor Loubser, and I have been asked by LEAD to just take you through your study material, perhaps bring some clarity to problematic areas, of which unfortunately there are quite a few because of the bad drafting that we find in Chapter 6 of the Companies Act. And I will then also update you on more recent case law. Now, I want to, first of all, emphasize that I am not one of the lecturers involved in officially teaching this course. So you mustn't take anything I say as an indication or a clue of what you will be asked in the exams, because I have no idea what they will be asking you. I have no role to play in the formal offering of the course. I am really just trying to bring clarity and explain problematic areas in the work. Then secondly, as we go along, I will be mentioning or telling you about new case law, judgments that were issued after the textbook was cancelled and that are not included in the notes. Your lecturers told me that you will not be penalized if you don't mention these cases should any of the questions deal with the subject on which these judgments were issued. But I must say, I don't think that is a very satisfactory situation, because you have to know about these judgments anyway for practical purpose in case you ever encounter this problem or a similar problem in practice. So my advice would be, make a note of these judgments. You don't have to read the actual judgments. You can just make a note in your study guide and in your study notes so that you are updated, because otherwise some of your answers in the exam will actually be wrong. And even if you are not penalized for it, you have to know the correct answer for future reference anyway. So I think you should take note of the new judgments. They are mostly Supreme Court of Appeal judgments, which means they are very important and you have to take note of them. I think that's basically all I wanted to say as an introduction. And I am now going to switch off the video because it sometimes impedes the sound. So it's better if my camera is turned off and only the microphone is on. Right, so we start with study unit 1. I'm going to follow the order of the textbook because I think since the textbook is really your basic source of information, it's probably the best one to use as a basic. But please do not ignore your study guide or study notes, and do not ignore the Act and the regulations. These three sources should all be used. And then the other thing is, as I've mentioned already, Chapter 6 is very badly drafted. So the case law that you find in your textbook and in your study notes is important, because we've had to rely on the courts to tell us what some of these rather obscure and convoluted provisions mean and how they should be interpreted and applied in practice. So you cannot really just look at the Act and know what they wanted you to do or what it meant. We have had to wait for the courts. And of course, you will see that there are still differences of opinion among the High Court divisions. So in that case, only once the Supreme Court of Appeal has adjudicated on this point will we know for certain how to interpret and apply these provisions. Right, so going to let me just see. I am going to change this slide. I was just for 1 minute not sure whether you can see the slides. Yes, I hope so. Okay, so we are in the introduction, and I think I just wanted to make sure that you can see the slides, but I think so. So in the introduction to chapter 6, or then rather of the chapter 12 of your textbook, you will see that there are various options for a company with financial problems. In other words, it's not just business rescue. There seems to be a culture among some people that sort of a knee-jerk reaction. The moment they have financial problems, they immediately decide that business rescue is the answer. And business rescue is definitely not always the best solution to financial problems. Liquidation can also be used as a business rescue method, or even to rescue a whole company or close corporation. And you will see that particularly when we get to the last study unit dealing with a compromise with creditors, where you will see how liquidation combined with a compromise can actually rescue a company or close corporation. There's informal structuring, of course, but as well, but then nobody is bound unless they have agreed to it. So that is a slightly more risky way of trying to solve your financial problems. You will see in your introduction in the textbook that business rescue replaced judicial management, which was the corporate rescue or company rescue procedure under the 1973 Act, and also under the 1926 Companies Act, which was our first Companies Act. Business rescue is applicable to companies and close corporations. And there you will see the latest statistics that I could find are the ones made available by the CIPC in June 2022, where you will see that 69% of business rescue cases are for private companies, 2% for public companies, 1% for non-profit companies, and 28% for closed corporations. Now, as you know, it is no longer possible to register a new closed corporation. So slowly but surely, the statistics for closed corporations will become lower, because they will eventually disappear from the scene. Okay, then we go on to study unit 1. The definitions in section 128. The definitions are very important because the drafters of this chapter somehow decided to include concrete law into some of their definitions. The courts have remarked on this, that it's a strange place to find, for instance, the goals of business rescue. You would have expected something as important as the goal of business rescue to be in a section on its own, but it's included in the, almost hidden away in the definition of business rescue. So there you will see that business rescue is then defined. The first two parts of the definition actually refer to the procedure, which is that it's a temporary supervision by a business rescue practitioner, and there's a temporary moratorium. And then in the third part of the definition, there's the reference to the plan, and then you find the goals of business rescue, of which there are two alternatives. The one is to rescue the company itself, in other words, to return it to solvency. Or alternatively, if that is not possible, then to get a better return for creditors, on the assumption that if you sell the business or the assets of the company in a business rescue rather than in liquidation, you will get higher prices, and so your creditors will benefit from that. Whether that is actually true is not such a absolute fact, because there is really no reason why you couldn't get the same prices. For instance, selling a business as a going concern from liquidation, you should actually be able to get the same price as when you are selling it out of a business rescue. Originally, some of the first High Court judgments, the judges were a little bit negative about this, the alternative goal, and they said you must at least first try to rescue the company itself. don't commence business rescue with a mindset that the company cannot be rescued, but will get a better dividend for creditors. But the Supreme Court of Appeal in Oakland said, no, the two goals are actually on the same level. So you can actually commence business rescue knowing that the company can no longer be rescued and that you are just going for the other goal, which is to get a better return for creditors. So rescuing the company is then defined as achieving one of the two goals of business rescue. Affected persons also important because they are supposed to play a prominent role in business rescue. So the affected persons are creditors, shareholders, registered trade unions, employees, or their representatives. Now, the Labour Relations Act does not require a trade union to be registered, but for purposes of business rescue, only registered trade unions are recognized, but then unregistered trade unions will then be able to act as the representatives of the employees, and then only employees who have no union to represent them will then have to represent themselves. The definition of financially distressed is also very important because that is the first requirement for commencement of business rescue, and there you have two options. It's either the inability of the company to pay its debt, in other words, commercial insolvency, or where the liabilities of the company exceed its assets, in other words, factual or balance sheet insolvency. Right, so there are two ways in which to commence business rescue. The first one is the filing of a board resolution with the CIPC, and 91% of business rescue cases are commenced by this way for obvious reasons, because it's much faster, it's quicker, it's easier. So it's obviously the preferred method. 9% of cases commenced by way of an application to court, and that would really only be the situations where it is no longer allowed for the board to file a resolution, and then you have to apply to court. Okay, so now we get to study Unit 2, which is commencement of the business rescue proceedings by board resolution. The resolution, now please note that only the board of directors of a company may pass this resolution to commence business rescue, not the shareholders. They have no say in this. So it's only the board that can pass this resolution. If it has reasonable grounds to believe that the company is financially distressed, which I've just told you, there's a specific definition for it, quite importantly, and there appears to be a reasonable prospect of rescuing the company. Now you will see that section 129(7) provides that if the board comes to the conclusion that the company is financially distressed, they must explain. If they decide not to adopt a resolution commencing business rescue, they must explain this failure to adopt the resolution to all affected persons. So they must actually send a notification to all affected persons explaining why they did not adopt a business rescue resolution, although the company is financially distressed, or they have come to the conclusion that the company is financially distressed. Now, obviously, if a company sends out this type of notice to all affected persons, the creditors are going to scramble to get some payment in some way, because now they know that the company is probably unable to pay its debts. So they will try to find a payment, or to get payment, or to institute proceedings before the company goes into liquidation. So for that reason, quite obviously, almost no company sends out a notice like this. And because section 129(7) does not contain any sanction, which says what will happen if the company fails to send out the notice, there is no there are no consequences to not sending this out. You could perhaps at a stretch say that it was a breach of their fiduciary duties or a breach of the contravention of the act, but you're probably not going to get very far with that. So the companies just don't do it. The only case that I know of where a company did send out such a notice was when the company actually wanted to go into liquidation but didn't have the funds to pay for a liquidation. So they sent out this notice knowing that some or one in their group of creditors will definitely apply for the liquidation of the company, and then the applicant will have to pay the costs, and then the company will not have to pay the costs because he couldn't afford to pay. So that was a very intentional sending out of the notice, but usually companies don't do that because they want to keep it quiet that they are in financial distress. Section 129.7 does not require or does not mention the reasonable prospect of rescuing. So even if the directors decide not to commence business rescue because they don't believe there's a reasonable prospect of rescuing the company, they must still send out this notice, but then obviously it will say it's because we believe liquidation is the only option. But as I said, most of them don't send it out anyway, so it's not really a problem. Then we have De Bruin versus Conradi, the judgment in De Bruin versus Conradi. I think it's in your study notes, where the court held that if the company's memorandum of incorporation stated that the company may not, or the directors may not commence judicial management without the approval of the shareholders, then they can't do it, or they are prohibited. And the court said, well, this will apply then to business rescue. That is wrong, because judicial management was not something you could commence by filing a board resolution. It was a completely different situation. You had to apply to court, and I don't think simply replacing judicial management with business rescue in this provision or section of the part of the memorandum of incorporation was probably incorrect. Right, now the board resolution quite obviously must be valid. It must be a valid board resolution. In other words, it must comply with the requirements of section 73 for a valid board resolution. So these are the requirements dealing with a quorum, notification to all directors, a majority vote in favor of the resolution, etc. If this resolution is not valid, then the business rescue did not commence validly because of the problem with the resolution. There was a case, it's mentioned, I think, in footnotes, in various footnotes in your textbook and also in your notes, I think. But anyway, DH Brothers, the case of DH Brothers, there the company had two directors and only one of them signed the resolution. So the court held that this resolution was invalid because the act requires for a valid resolution a majority, in other words 50% plus one. And if you only have two directors, then both of them have to vote in favor of this resolution. Right. The resolution only becomes effective when it is filed with the commission. And you will see there's a practice note 3 of 2021. You will find that on the CIPC website under business rescue, where they give you detailed instructions on how this resolution must be filed, as well as the documents that must accompany this filing. So you cannot just file the resolution and hope for the best. You have to follow the practice note, and only electronic filing is accepted, and there's a special email address for it. So you have to follow that practice note. So you must take note of the practice note when you file a resolution. And it's quite a long list of documents that are required for filing. Also, although the Act states that business rescue will commence when it is commenced by way of a filing of a resolution, when the resolution is filed with the Commission, in actual fact, the approach or the policy of the Commission is it doesn't start immediately with mere filing. the business rescue will only commence once they have acknowledged receipt of the filing and they have confirmed that all the necessary requirements and documents have been filed and met, and only then will the business rescue commence. Right. Now, the Act goes on to say, a business rescue resolution may not be adopted in this way if that, and note it says adopted, not filing, although the Act very specifically states that the business rescue resolution has no force or effect until it has been filed. In spite of that, the board may not adopt such a resolution if liquidation proceedings have already been initiated. Now, there's no definition of initiate in the Act, and it's not a known legal term. So nobody really knows what they mean by this. When can you say that liquidation proceedings have been initiated? Now, the first case, and you will find the detailed discussion of that in your textbook on page 291. The first case where this was mentioned was in Imperial Crown, First Rand Bank versus Imperial Crown Trading, which is mentioned at the bottom of the page. So the cases are not really listed chronologically. But that was the first case. And there the court said, we don't know what initiate means, and it will lead to unnecessary complications and confusion if we give it a different meaning. So we must assume that initiate means the same as commence. So when do liquidation proceedings commence? When the application is filed with the court. The moment your liquidation application is issued by the registrar of the court, that's when the liquidation proceedings commence. And that seemed to be the accepted view for quite some time, until in 2019, all of a sudden we had two judgments on this issue, but they are in conflict with each other. The first one was the Cheka Training Matters case, where the court said this cannot be because you cannot expect the directors of the company to know about liquidation proceedings if the application, the liquidation application, has not been served on the company as yet, which is a requirement for the commencement of liquidation. So in the Cheka Training Matters, the court said it must be served on the company only once the liquidation application has been served on the company and not merely issued. Then you can say it's been initiated. So according to this judgment, initiate is something that comes after commencement, which is not what you would expect from the ordinary meaning of initiated, but the court felt that that was really the fair option. But then in the Mouton versus Park 2000 development case, the court held exactly the opposite view. And there it was decided that initiate, the ordinary meaning of initiate, means when you take the first steps. They refer to it as the preceding causative act or conduct. In this particular case, it was where the creditor company decided, the directors took a resolution that they were going to apply for the liquidation of the debtor company. So in this case, the court held that's when the liquidation proceedings were initiated. They were initiated when that resolution by the creditor company was taken that they are going to apply for liquidation. So that comes before formal commencement of the liquidation proceedings. Then that was already the fourth case, was the Pan-African Shopfitters case. Now, that case is mentioned on page 292 of your textbook, but there is a mistake. There is a quote from the judgment in the Pan-African Shopfitters case, but that quotation was actually the judge quoting from the Mouton versus Park 2000 case. It was not his own conclusion. For some reason, the judge felt that it was necessary to quote extensively from both the Mouton case and the Checkard case, as a result of which his judgment ran into, I think, if I remember correctly, 104 pages. So the quotation in your textbook comes actually from, it does come from the Pan-African Shopfitters case, but it was the judge quoting from the judgment of the Mouton versus Park case, and then saying right at the end, but I don't agree with this view. So you will see what this is really what the judge held in the Pan-African Shopfitters case. I subscribe to the conclusion reached in Checkard. So he did not agree with the Park case. The liquidation proceedings must be issued and served on the company to meet the requirements of the section for reasons set out in the judgment. So the interpretation in Mouton does not seem to be a sensible one. So in this case, the judge agreed with Checkard that until the liquidation application has been served on the company, so that the company knows about the liquidation application, they are not prevented from taking a business rescue resolution, because they cannot be expected to be bound by something that they don't even know about. Okay, so that is now the correct situation. So please delete that section or that part in your textbook, or just make a note that this actually comes from the Park case and not from Mouton case, as the judge referred to it, and that it was not actually the view of the judge in the Pan-African Shopfitters case. So we think that if now at this stage we don't have a Supreme Court of Appeal judgment on this issue, but we suspect that if the Supreme Court of Appeal has to decide, they will probably agree with the Checkard case and the Pan-African Shopfitters case, because that seems to be a fairer situation. And you will see later on, when we talk about commencement of business rescue by way of a court application, you find a similar view, but in a different context, which is an indication of what the court will probably hold if they have to decide about this. Right, when we get to procedure, it is quite a tight procedure with fairly short periods. Within 5 business days after filing the resolution, the company must notify every affected person of the resolution with a supporting affidavit, appoint a business rescue practitioner, but you may ask the CIPC for a longer time, but you must ask that before the 5 business days have expired. Then you must file a notice of the appointment of your business rescue practitioner with the Commission within 2 days after appointing this practitioner, and then you must notify affected persons within 5 business days thereafter of the appointment, so that they know who the business rescue practitioner is that they're dealing with. Now, there are obviously good reasons for all these notification requirements, because, as I said it right at the beginning, the board takes this resolution. They are not compelled to consult anybody else. They don't have to consult creditors. They don't have to consult the shareholders or the employees. They take this resolution, they file it with the CIPC, and nobody will necessarily know about that. Now, obviously, the wiser thing would be to at least tell your primary or your biggest creditors of your plans, but they may not be sympathetic. So sometimes directors decide not to tell anybody before the time. They just file this resolution, and next thing, the company is in business rescue and nobody even knew. So that's why you have these very extensive notification requirements. Right, now, because the CIPC is at this stage, it knows about the resolution. The resolution must be filed with them, but they won't know if the other requirements have been complied with. And because it is so important to notify the affected persons, you have section 129.5, which is an effort to force the company to comply with these notification requirements, and very importantly, to appoint a business rescue practitioner as soon as possible, but within 5 business days. So section 129.5 stipulates that failure by the company to comply with all these procedural requirements in subsections 3 and 4 will have the result that the resolution lapses and is a nullity. Now, obviously, if the resolution lapses, there can't be a business rescue because you need a valid and binding resolution to commence business rescue. And then the section goes on to say that no further business rescue resolution may be filed by this company for the next 3 months after adoption of the lapsed resolution, unless they get the permission of the court. So they have to apply. It's an ex parte application, so it's done. It can be done very quickly, but they cannot just file another one. So the first question then was, would substantial compliance with the requirements be acceptable? Now you will see in your textbook, page 293, in ex parte van den Steen, the company, but not intentionally, but accidentally, did not notify all their creditors. And that was because they were told that this group must not be regarded as creditors, but in the end they actually were. So these people were not formally notified, but they knew about this business rescue because there was a notice on the company's website and advertisements or notices placed in local newspapers. So these creditors knew about it, and they were quite happy to accept that they were not formally notified. So in Van den Steen, the court said, well, if you look at section 6, subsection 9 of the Act, it states in any case that substantial compliance with any notification requirements in the Act is acceptable. So you only have to comply substantially. However, Section 6, subsection 9 only deals with notification and substantial compliance of that. It does not state that it does not deal with any other type of compliance. So in the Advanced Technology and Engineering Company case, which was one of the first to deal with this, where a business rescue practitioner was not appointed within the required 5 business days after filing the resolution, the court said there can be no substantial compliance here. If you do not appoint a business rescue practitioner in the stated period, then your resolution will lapse and be a nullity. There's no such thing as substantial compliance, which makes sense because you cannot have a business rescue without a business rescue practitioner. You must have a practitioner to start the procedure and to carry it forward and to take over management of the company. However, and that is where we have a problem, is that the Supreme Court of Appeal had to deal with the case in Panama Properties versus Nell, where some of the procedures or requirements had not been complied with. And here, the Supreme Court of Appeal decided that although the resolution lapses and becomes a nullity because of non-compliance with the requirements, the business rescue does not end. You have to apply to court to ask for the resolution to be set aside, which doesn't make sense because if the resolution is invalid, it has lapsed, it is a nullity. You cannot set aside something that doesn't exist anymore, but the Supreme Court of Appeal did not have a problem with that, and they said that it cannot automatically end just because the requirements were not met. So you still have to apply to court for the business rescue to be terminated on the grounds that the procedure or the procedural requirements were not met. And why they said that, you will see in the next slide. Because, as you've now seen, the board of directors take this decision. They don't have to ask anybody or consult anybody else. So the possibilities for abuse are quite endless, and as we have seen in practice, there is quite a lot of abuse with business rescue proceedings. It is very often used for the wrong reasons, and very often to stop liquidation proceedings. So or to just sabotage a liquidation. So very often you will find that business, well, no, sorry, you can't stop a liquidation. We'll get to that later. But when the directors realize that they can see problems coming, or a creditor has obtained a judgment against them and wants to sell some of their assets, then they quickly file this resolution for no other reason than to sabotage the sale or the auction. Also, the shareholders or the other creditors may not agree with the situation that the company should be in business rescue. And for that reason, Section 131 creates 3 remedies for affected persons, which is that any affected person may apply to court for the board resolution to be set aside on specified grounds. Now you will see that there are 3 specific grounds in the Act for setting aside this business rescue resolution. The first one is that there's no reasonable basis to believe that the company is financially distressed. Now, that doesn't happen very often, because in most cases the company is in serious financial distress. The second ground on which you can apply for the resolution to be set aside is that there is no reasonable prospect that the company will be rescued. Now, because a business rescue practitioner does not have the same authority as the liquidator to investigate the actions of the directors before business rescue commenced, many directors use business rescue to prevent a liquidation application so that there will be no investigation into their actions. And unfortunately, sections such as Section 417 of the Companies Act, where directors can be subpoenaed to appear before the master or a commissioner, and can be taken under cross-examination, that is not available in business rescue. So that is one way in which directors try to hide their activities which were not quite above board. However, as a result of Panama versus Nel, a 4th ground in Section 130 subsection 5, which is that a court could set aside the resolution if it is just and equitable. And that was very clearly a 4th ground, because there was an or in Section 130 subsection 5. So subsection 5 provides that the court may set aside this resolution because there's no financial distress, because there is no prospect of rescue, or because the procedural requirements were not met, or because it's just and equitable, and the court regarded it as just and equitable. Now, first of all, the court said the 3rd ground, which is that the procedural requirements were not met, means that the Act does not really intended the business rescue to end automatically if the procedural requirements were not met, because otherwise it would not have been grounds for setting aside the resolution. Now, there is an explanation for that, which I won't go into, but anyway, it is just another example of very, very bad drafting of this chapter, where you basically have conflicting provisions. But then the 4th ground was if the court regards it as just and equitable. Now, this was really a very beneficial or a good provision, because sometimes for an affected person who is basically an outsider, it's not so easy to show that there's no prospect of a rescue. But if the court could see that this was clearly on the evidence provided that this is an abuse of the process, it could have set aside the business rescue resolution on that grounds. However, now the Supreme Court of Appeal has said that the or must now become an and. So the Supreme Court of Appeal is now legislating and amending the act by saying that or becomes an and. So there are only 3 grounds for setting aside the resolution, and in all cases, apart from proving that ground, you must also prove as an applicant that it would be just and equitable to set aside this resolution, which makes it even more difficult for an affected person to have this resolution set aside. The second remedy is for the appointment of the practitioner to be set aside. You will see that the requirements are specified on or the grounds on which this can be done. What is important is that if an affected person applies for the appointment of the practitioner to be set aside, in other words, they have no problem with the business rescue itself, they just don't like or trust this practitioner, the court can actually say, well, you know what, we don't think that this is a good case for business rescue. They can ask the practitioner to provide them with a report and then decide that instead of just setting aside the appointment of the practitioner, they are going to set aside the resolution so that the business rescue proceedings will terminate. So although that was not the intention of the applicant, the court can still do that. Right. The third remedy is that an affected person may apply to court forcing the business rescue practitioner to provide security for the proper performance of his or her duties. Now, when you see some of the catastrophes that business rescue practitioners create, it is a good idea to always demand security. Before a company appoints a business rescue practitioner, they should say, this is our condition. It's not a condition of the Act. It's our condition. You have to set security. And in the King report, I think it was the fourth one, the third or fourth, the King report states that it is part of the fiduciary duties and duties of care of directors to require a business rescue practitioner to provide security for the proper performance of his or her duties before they appoint that business rescue practitioner. But if you don't do that, and at some stage you become aware of the fact that you have a dud here as your business rescue practitioner, then one remedy would be to demand security. But for that, you also have to apply to court. Now, this is actually completely against the principles of our law up to now, because you will probably know that if any person is appointed in a fiduciary situation, either as a liquidator or an executor or a curator or a trustee of an insolvent estate, it is always a requirement that you must first provide security before you are officially appointed. So the business rescue practitioner is the only person in that type of situation or position that is not required to provide security, which is really a fairly serious weakness in the Act. But maybe the drafters, because they were not South Africans, maybe they didn't know that it is in our legal tradition that you must always provide security. So it is not a requirement for business or for appointment as a business rescue practitioner. Another thing that is important is that these remedies in Section 130 only exist until a plan has been approved in the business rescue. So once the plan has been approved, it doesn't matter what was wrong with the board resolution or the practitioner or whatever, you cannot use Section 130 anymore. As one judge put it, it's any deficiencies there might have been are now only of historical importance. You cannot do anything about that. Okay, so now we go on to study Unit 3, which is the alternative way to commence business rescue proceedings by an order of court. As you've now seen, a board cannot file a business rescue resolution once liquidation proceedings have been initiated, whatever that may mean. So in those cases, then if you want to put a company into business rescue, you have to apply to court. What is important, however, is that only an affected person may apply to court. You cannot apply the company itself cannot apply, and neither can a director or the board in their capacities as such. Of course, directors are usually also creditors or shareholders of the company, so in that capacity, they may apply to court for an order to commence business rescue. I have underlined the words at any time, because you will see that a very important interpretation has been attached to those words. Right, so a copy of the application must be served on the company and CIPC. In other words, it must be formal service by the sheriff. All affected persons must be notified. So you don't have to serve the application on them. You can just notify them. Now you will see that on page 298 of the textbook, there's an extract from a case where very early on, where the court said this is very difficult. It's a very heavy duty on an applicant to notify everybody. It did not actually in practice provide such a problem, because it's done by email or by placing a notice on the website of the company, putting up notices at the workplace. So that has not really turned out to be such a big problem. But these are very definite requirements that you must notify the affected persons, and then the Act and the regulations contain very strict instructions and requirements on how the notification must take place. Right. Now, the next problem we have with an application for business rescue, which is found in section 131(6), stating that if liquidation proceedings have already been commenced, the application for business rescue will suspend those proceedings. Now note, it doesn't say a business rescue order. The mere application for business rescue will suspend the liquidation, which is a fantastic invitation for abuse of a business rescue application. You often find these applications are filed with the court just a day or two before the auction in the liquidation will take place, or something like that, or just a day before a Section 417 examination is due to take place. So you can clearly see that there is the idea or the intention behind this application, the filing of this application, is really to stop the liquidation and to stop something unpleasant from happening. So it is a very clear abuse, and it was to be expected. Why the drafters did not see that coming, and why they did not at least require a business rescue order, I don't know, because very often these applications are dismissed by the court, but it could take months before it actually gets to court and before it is dismissed, and in the meantime the liquidation is suspended. Now the first question was, when has a business rescue application been made? Because this subsection 6 states that the application, if the application is made, it will suspend the liquidation proceedings. Now, just as in liquidation, the normal meaning of an application, the commencement of an application, is when you file your application with the registrar of the court issues you with, or the registrar office issues you with a case number. That's the moment of commencement. So strictly speaking, the moment you file your application with the court, and the application is issued by the registrar, then the liquidation proceedings will be suspended. The courts could not quite agree about this, But eventually we now have, and this is a new case which you will not find in your textbook or in your study notes or study guide, Luchman versus African Global Holdings. I believe that in your study notes there is a reference to the High Court judgment. You can really scrap that and replace that with the Supreme Court of Appeal judgment, which said that the application will the business rescue application will only be regarded as having been made for purposes of suspending the liquidation proceedings once it has been served on the company and the CIPC and all affected persons have been notified. So it doesn't suspend the liquidation immediately when the application is issued by the court, but when it has been served and all affected persons have been notified, then the liquidation proceedings will be suspended. The next question then was, what exactly will be suspended? The Act talks about liquidation proceedings. So the various divisions of the High Court had serious differences of opinion. Some said it refers to the legal proceedings. So once you have a final liquidation order, you can no longer apply for a business rescue order because the liquidation, it's not, the proceedings have now been completed. It's too late. Others said no, the legal proceedings can go ahead. In other words, the application for the liquidation, if it hasn't been finalized, but the words liquidation proceedings actually refer to what follows after a final liquidation order has been issued. In other words, the liquidation of assets and this, in other words, the sale of assets, paying of creditors, etc. Others said no, it's the whole thing. We have now come to the point where the courts have now held that it is actually the whole thing. First of all, there was the Richter versus Absa case, which is in your textbook, where the court said Section 131 states that an application for business rescue may be made at any time. And that means it can even be made until a day before the company is dissolved and deregistered after the whole liquidation process has been completed. In other words, it doesn't stop. The possibility is not excluded. No matter how far the actual liquidation has progressed, assets have been sold or creditors have been paid, the moment the business rescue application is filed, and then, as we now know, served and notified, then the liquidation will be suspended. So, in other words, it can be done at any time until the liquidation has ended. Then the question then was, okay, if the liquidation proceedings have been suspended, what does that mean for the liquidators? Obviously, and we find that in the CardioFitness case, which I think is in your study guide, your study notes. In the CardioFitness case, the court said, well, the suspension of the liquidation proceedings does not mean that the liquidators have been removed from office. They are still there. They are still responsible for the protection of the estate of the company. It's just that they cannot continue with the liquidation. In other words, they cannot sell assets, they cannot pay creditors, but they still have to look to or protect the estate of this insolvent estate of the company because they are still there and they still have their duties. Then came the case of Maroos. First of all, in the Gauteng Pretoria High Court, where the judge that was not satisfied with this situation. So the judge said, well, okay, you can't really say that the control of the company and its assets will be returned to the directors, because it's clear that when liquidation commences, then they are removed automatically. The directors lose all their powers. But we can't say that the liquidators still have any power. So the court here appointed a manager, and this manager was the person that the directors intended appointing as, or the applicants intended appointing as the business rescue practitioner. That was incomprehensible. There is no provision in the Act anywhere that states anything about appointing a manager in the interim or anything like that. Fortunately, this case was taken on appeal, and the appeal court brought some sanity to the situation and said, there's no provision for an appointment of a manager. There is no reason to appoint a manager because the liquidation proceedings have not been terminated. They have only been suspended, because if the business rescue application is dismissed, then the liquidation will automatically go ahead. So you cannot say that the liquidators no longer have any powers over the company or its assets. They cannot continue with the liquidation process, but they are still in place, they still have their duties, and they still have control over the assets of the company until a business rescue practitioner is appointed, and that will obviously only happen if the application for business rescue is successful. But the directors, under no circumstances, will be reinvested or revested with the assets of the company. They have no powers. Their powers ended, and their authority ended when the first liquidation order was issued, and they will not be reinstated. So they have absolutely no powers. The liquidators are still in place, and they are still responsible for protecting the estate until the business rescue practitioner is appointed. And on those grounds, the court also held in the case of Miller versus Becker to say that a Section 417 examination that has already started will not be terminated by an application for business rescue, because the liquidation itself has not been suspended, the liquidation order. It's only the proceedings, the actual selling of assets and paying creditors. So a Section 417 examination can go ahead. Okay, then the grounds for a business rescue order. Now, the grounds for a business rescue order are basically the same for the resolution by directors. But there's an important difference, which is that if directors decide to file a business rescue resolution, to take and file this resolution, although it is a requirement that the company must be in financial distress and they must have reason to believe that there's a reasonable prospect of rescuing the company, nobody actually checks those requirements, whether they have been met. It is absolutely, totally up to the directors to decide whether these requirements have been met. It's only if somebody applies for the resolution to be set aside that the court will, for the first time, investigate whether the grounds exist. The CIPC has no authority to investigate when a business rescue resolution is filed. So although theoretically the directors must make sure that these requirements are met, nobody actually can stop them if it isn't. It will only be afterwards when somebody applies for the resolution to be set aside. However, when you apply to court for a business rescue order, in other words, for commencement of business rescue by way of an order of court, then there are specific requirements, and these requirements, the court will have to be satisfied that these requirements have been met. So basically, these requirements are, firstly, that the company is financially distressed, and for that you look at the definition of financial distress, or alternatively, that the company has failed to pay any amount in terms of an obligation with respect to employment, and we'll talk about that later on, or it is just unequitable to do so for financial reasons. And then the second requirement is, and there is a reasonable prospect for rescuing the company. So these are the basic requirements. So, as far as financial distress is concerned, the definition makes provision for either commercial or factual insolvency. That's important because for liquidation, commercial insolvency is required, not factual. So commercial or factual insolvency will qualify a company for business rescue. However, when you look at the definition, you will see that it refers to a commercial or factual insolvency within the next immediately following 6 months. In other words, it actually makes provision for business rescue in the future, because it's in the next 6 months and it's phrased in the future tense. So initially, some courts held that if a company is already insolvent or already unable to pay its debts, it's a progress beyond the point of financial distress. Now it must go into liquidation. It doesn't meet the requirement of financial distress anymore because it is already insolvent, and the definition talks about future insolvency within the next 6 months. So you will find that in Gormley versus West City Precinct, and also First Rand versus Lodi 5. However, in the Oakdean Square Properties case, which was the first judgment by the Supreme Court of Appeal on business rescue, the court said no. Even if a company is already insolvent, it can still qualify for business rescue, but then, of course, you will have to look at the prospect for rescue. But the court said, in actual fact, if a company is already insolvent, either commercially, well, the court specifically in this case dealt with commercial insolvency. The court said if a company is already commercially insolvent, it qualifies for both liquidation and business rescue, depending then on the circumstances of the case. As far as the alternatives for financial distress are concerned, the first one then is the failure to pay over employment-related amounts. You may remember that Denel, for instance, at one stage admitted they haven't paid over the tax or the unemployment insurance fund or the pension fund contribution of employees to their funds, although they have deducted the money from their salaries, but then Denel used this as working capital. So they kept the money, they didn't pay it over. Now, that happens more often than you would expect. So that in itself, so if you cannot prove financial or commercial or factual insolvency, which could be difficult for an outsider, especially an employee, if this happens just once, just one non-payment, 1 month, then you can apply for business rescue on that ground. The third alternative is if it is otherwise just and equitable for financial reasons. Now,